Ms. Pearson, can you hear me? Stephen, can you hear me okay?
I can hear you loud and clear.
Okay. Lucy communicated with the court coordinator that basically she has a medical test scheduled this afternoon.
Yes, sir.
So she was just going to reset 2 of her cases and then waive the arraignment.
Sounds good to me.
That doesn't present a problem for y'all.
No, sir.
Okay.
No. No.
Are you on there? Can you send a chat to Lucy?
I'm here.
Lucy, you're free to leave. Your cases are going to be taken care of.
Okay, thank you, thank you. I am faxing over a waiver on Mr. Dash right now before I get out of here.
Perfect. Thank you.
Uh-huh.
Okay, if you can hear me in the jail, Ms. Pearson's clients do not need to be brought to the hearings today.
Yes, sir.
Thank you. All right, Stephen, I'm showing that Dustin Lee is in Coryell County. Is that correct?
That's what I showed you. Sorry. Yeah, go ahead, Ben.
Looks like it, Your Honor.
Okay. So we're going to start out with Jacqueline Barnett.
Believe so.
Okay. We're just going to run straight down the docket,
Yes, sir.
theoretically.
Straight down the docket.
Okay.
Straight down the docket. Remove Lucy Pearson's clients. They will not need to appear.
Are you Miss Barnett?
Sir.
Court will call cause number B19-914, B20-105, 106, 512, 364, and 365. The state of Texas versus Jacqueline Barnett. Let's start out with 364 and 365, which are set for arraignment today. And it looks like we have waivers of arraignment in both of those. And Ms. McCollum, you have B2512 also, is that correct?
I do, Your Honor.
Okay, in that case, for purposes of pretrial, do we have any pretrial issues to address?
None from the defense, Your Honor.
State?
None from the state, Your Honor. And I was in negotiations with Ms. McCullum and then Mr. Danford this morning at lunch. And so I think we're going to be coming close to a resolution on it. I just need to touch base with Ms. McCullum.
We just need to reset for November 1st.
Your
Yes.
Honor, I think we can agree to a plea date if Ben's ready on that.
I want to talk to you first. So let's just do a reset to November 1st. And then if we get something in before then we'll take care of it.
Okay, sounds good.
Now let's talk about the other three. B19-914, B20-105, and 106. I believe Mr. Danford is involved in each of these. Is that correct?
That's correct, Judge.
Mr. Hurd, do we have any issues to address on those today?
Nothing from the defense, Judge, and we're anticipating a plea agreement. And I think the best course of action, if the court is okay with that, is to run it with the public defender's office cases so we can enter the plea all at the same time.
All right, we will see everybody back on November 1st.
Thank you.
Thank you, Ms. Barnett.
Thank you.
Your Honor, I have nothing further. May I be excused?
Absolutely, thank you.
Thank you. Y'all have a good day.
I don't have anything on mine.
Hey, Dan, your mic is on. Is thanks.
All right, ladies and gentlemen, if you can hear me, if you are on this current Zoom hearing and you are not an attorney in this case or an active participant, i.e. a witness for a particular hearing, I would ask you to please sign off of the Zoom, and you're more than welcome to watch these hearings on YouTube. We are broadcasting live on YouTube. But the more people we have on here, the smaller everybody's picture gets, and I'm a little bit old. So bigger pictures are better. Okay. Thank you.
Good afternoon, Your Honor.
Good afternoon. Court would call cause number B21-231 and B21-442, the state of Texas versus Aurelia Escalante.
Judge,
Yes.
this is Miss Galloway Gardner.
Ben, is she reset or not?
She's reset to November 5th.
Okay. Ms. Gardner, you're free to leave, and we'll see you back on November 5th. Thank you.
Yes, sir, thank you. God bless you. Now you want Escalante, sir?
Please. For a jail docket? Okay. I'm guessing the jail just sent those over. Court will call cause number B21-231 and B21-442, the state of Texas versus Aurelia Escalante. In 442, I'm showing that a waiver of the arraignment was filed, so the court will enter a scheduling order in that case. In B21-231, for purposes of pretrial, let's say the parties.
State's ready.
Defense is ready.
Do we have any pretrial issues to address?
None from the state, Your Honor. We've been in plea negotiations. I think we've come to a resolution, but pending Ms. McCollum speaking with her client. But maybe we can set it for a plea on the 5th, Lauren.
Yeah, that's great for me. We have reached an agreement.
Okay,
All
great.
right, we will reset it for November 5th at 8 a.m. Thank y'all.
Thank you.
Okay. They're resetting it? They're resetting it for November 5th.
I thought you said for our release
No.
for next Friday.
Not the call. Have her call you.
They're on the docket this afternoon.
Jennifer, Stacy, is that who you want next?
Correct.
If they reach the plea agreement, they're going to have a rate of 500.
Wait. Well, these I'm showing we've already pled or set for sentencing on 10/27. So why would we need them this afternoon? I don't know. Let's see if we can figure it out.
Yes.
Okay. Did you get an answer back from Galaxy AO? No answer. You sent the chat, right? Okay, done. Okay, we need to figure that. Feel free to send a chat on that one too. Court will call cause number B2464, B2577, and then 21-343 and 344, the state of Texas versus Jennifer Stacy. I have mixed notes on these, so perhaps it would be best to create or treat this as a status hearing so I can figure out exactly where we stand.
Sure, Your
Counsel?
Honor. I believe that Ms. Stacy, there was a plea agreement. She was out on bond. She picked up these new cases. And then there was a new pre-sentence investigation and sentencing date. I don't know, Brett, can you help fill in the gaps on that one?
Well, that is exactly right. We have a new date. We're waiting on the PSI. I believe Lisa McClellan was the one doing that one. I don't see that right at the moment, but we are doing a PSI on the one she's pled on. In our conversations, we have not yet come to an agreement, I don't think, of whether or not to plead on the new cases. Although she may be willing to do so. I don't believe we have done that. Is that correct?
Oh yeah, there's not any agreement.
Okay, that's what I
Yeah.
thought. Yeah. And we just hadn't reached an agreement yet to do that on the new cases.
So, Judge, in summary, she pled to a case. She got it set off for a sentencing, a PSI. She picked up these new cases, and then the PSI and the sentencing got punted out again out to December.
Okay, so the two new cases, we just need to set for another pretrial.
Yes, Your Honor. I believe that'd be correct.
Do we have any pretrial issues we need to address on 343 or 344?
No, Your Honor, not from the defense.
None from the state.
And the new sentencing date is December 1st. Is that correct?
Looks like it.
All right, let's set both of these for pretrial on November 19th. And then we'll figure out where to go from there.
Thank you.
November 19th. Yes, Your Honor.
November 19th.
I am scheduled for a jury trial in the county court of law that day. If you would like, we can just leave it, and then as it gets closer, I can file a motion for continuance if need be here.
I think that'd be great.
Yes, Your Honor.
Should get a response back from the iPad. Yeah, the other lady's trying to get back in. It says it's at one of our defendants' moms. Nadia Howe?
Yes.
Okay. Court will call cause number B. B 2020 and B 19748, the state of Texas versus Nadia Howe. For purposes of pretrial, let's say the parties.
It's ready.
Defense is ready, Your Honor.
Do we have any pretrial issues to address?
None from the state, Your Honor.
Judge, I know we had filed a motion to suppress, and Mr. Harpold and I were going to do some homework and then confer. I'm not sure if he's at that point, if we need to set the motion for a contested hearing or set another pretrial.
I'm looking at, this is on,
Nadia Howe, Stephen.
I would say that, I would go and just, let's set it on a motions docket, and then if that way we'll have it. And then if we figure out something, Cheryl, we can then take it off.
That works for me.
Okay, let's set the contested motions on December 1st.
Thank you, Your Honor.
And then we'll set a pretrial on the 13th if we need it. All right, Ms. Howell, we'll see you back on December 1st. Thank you.
Thank you. Judge, on the 1st, is that also at 1:30, the contested docket, or is that at 9?
That's a really good question. Let me look.
I just want to make sure I get it at the right time on my calendar.
No, that's one of those Wednesday dockets.
I think
Stephen, do you show
we're
that's at 10:30?
I believe it's at 10, Judge.
10, okay.
O'clock. Okay. Court will call cause number B 2143 and B 2414, the state of Texas versus Samantha Cooper. For purposes of pretrial, let's say the parties.
State's ready.
Defense is ready, Your Honor.
Do we have any pretrial issues to address?
None from the state, Your Honor. But Ms. McCollum and I have been in plea negotiation this morning. I think we might be close to a resolution. We just need another pretrial, I think would be good. Right, Lauren?
Correct. And we did do an agreed reset for the trial date of 1/4/22.
All right, let's set a pretrial on December 13th. We'll see everybody back then.
Thank you, Your Honor.
That says they're in visitation.
Okay.
Court will call cause number B20 543, 544, 545, and 546. The state of Texas versus Joshua Kinsel for purposes of pretrial. What say the parties?
State's ready.
I'm here, Your Honor. I'm ready.
We have any pretrial issues we need to address?
Not from the defense.
None from the state, Your Honor.
Okay, it looks like our next scheduled pretrial is November 1st, and we're set for trial November 2nd. So we'll see everybody back on November 1st. Thank you.
Yes, Your Honor. One, two.
Court will call cause number B19 329 and 842, and then B21 126, 127, and 128. State of Texas versus Cody Bates. For purposes of motion to revoke or pretrial, what say the parties?
State's ready. I believe Miss Perry and I had an agreement. Is that correct, Miss Perry?
Yes, sir. We filled out the paperwork. There should be a new case he's pleading on and 2 revocations. And then 2 dismissals.
I see the paperwork. Give me just 1 second. You ready? Cause numbers B19, 329, 842, and then B21, 128 for purposes of agreed pleas. What say the parties?
State's ready.
Defense ready.
Okay, the first document we need to go through is the joint request for plea or sentencing by video conference. It purports to have each of the parties' signatures. Mr. Bates, do you have any objections to proceeding today by video conference?
No, sir.
And cause number B21-128. Next document we need to go through is the 3914 Discovery Disclosure and Compliance Form, which purports to have each of your signatures. Is that correct?
That's correct.
That's correct, Judge.
To the best of your knowledge, has the state received all the discovery from law enforcement and forwarded the same to the defense?
Yes, Your Honor.
To the best of your knowledge, have you received all the discovery?
Yes, Your Honor.
Mr. Bates, I'm going to show you a document in this case entitled Defendant's Plea of Guilty, Waivers, and Admonishments. Did you have a chance to go through that document with your attorney?
Yes, sir.
Did you understand that document?
Yes, sir.
You understand that you have a right to a trial by jury?
Yes, sir.
Do you understand that you have a right for your attorney to cross-examine the state's witnesses and to call your own witnesses?
Yes, sir.
And do you understand you have a right to appeal?
Yes, sir.
Do you understand that you're waiving all three of those rights today?
Yes, sir.
In addition to that, do you understand that you have a right to remain silent? Nobody can require you to testify against yourself, but you can in fact waive that right.
Yes, sir.
Page 3 of this document purports to have your signature in 2 different locations. Is that your signature in both spots?
Yes, sir.
Your second signature appears below a paragraph entitled Judicial Confessions and Stipulations. Do you understand that by signing that paragraph, it's just like you stood up here before the court, raised your hand and said, I did what the state's accused me of doing?
Yes, sir.
Attached to the back of the document is a copy of the grand jury indictment. It purports to have your signature on the bottom. That's your signature?
Yes, sir.
And are you asking the court to accept as true and correct this grand jury indictment?
Yes, sir.
Do you feel like your client understands his rights, waivers, and admonishments in this case?
Yes, Your Honor.
On the Zoom hearing, the mic was echoing in. Okay, that's okay. Just so you know. Yeah. No, it's cool.
Yeah, I just muted him. Yeah. Mr. Bates, in this case, you've been charged with tampering with physical evidence. Tampering in physical evidence is a third-degree felony with a range of punishment of 2 to 10 years incarceration and up to a $10,000 fine. Do you understand this charge and this range of punishment?
Yes, sir.
And how do you plead?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, sir.
Are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
And are you a citizen of the United States?
Yes, sir.
Do you feel like your client's competent and capable of assisting you in preparation for trial?
Yes, Your Honor.
Is there a plea agreement?
Yes, Your Honor. And again, this is B21-128. There's 5 years confinement TDC JID. And this case is going to run concurrent with his 2 revocations.
Is that your understanding, Ms. Perry?
Yes, Your Honor, along with 2 dismissals, which I'm sure has been presented to you.
Correct. That's part of the agreement. It's count 1 and 2 of B21-126 and B21-127.
Correct. Mr. Bates, is that your understanding of the plea agreement in this case?
Yes, sir.
And do you understand that a plea agreement's an agreement between you and the state? It's not binding on the court, but if the court did not accept your plea agreement, you would have the opportunity to withdraw your plea of guilty, enter plea of not guilty, and proceed to trial.
Yes, sir.
And are you asking the court to follow this plea agreement?
Yes, sir.
The court will find evidence beyond a reasonable doubt to enter a finding of guilt. Pursuant to your plea agreement, will order you confined in the Texas Department of Criminal Justice for a period of 5 years. You have court costs in the amount of $290, reimbursement fees in the amount of $550. You have jail credit from January 17th of 21 to present. And this will run concurrent with your other cases. Do you have any questions on this one?
No, sir.
B19 842 and 329 are both motions to revoke. Is there any objection to going through the admonishments together?
No objection.
No objection.
Mr. Bates, I'm showing you one document, but in fact there's two, each of them titled definitively approved the state's motion to revoke. Did you have a chance to go through both documents with your attorney?
Yes, sir.
You understand in each of these cases you have a right to a contested hearing before the court.
Yes, sir.
In each of these cases, you have a right for your attorney to cross-examine the state's witnesses and to call your own witnesses.
Yes, sir.
And do you understand that you're waiving those rights today?
Yes, sir.
In addition to that, do you understand that you have a right to remain silent? Nobody can require you to testify against yourself, but you can in fact waive that right.
Yes, sir.
At the bottom of page 1 on each document, it purports to have your signature. Is that your signature?
Yes, sir.
And do you understand that by signing the bottom of the document with the stipulation of evidence paragraph right above your signature, it's just like you stood up here before the court, raised your hand and said, I did what the state's accused me of doing.
Yes, sir.
You feel like your client understands his rights, waivers, and admonishments in both cases?
Yes, Your Honor.
Attached to the back of each of these documents is a document marked as State's Exhibit A. Contains the allegations that were made against you in the state's motion to revoke. Did you have an opportunity to go through this document in each of these cases? Mr. Bates, did you have a chance to go through the exhibit where the allegations from the motion to revoke were noted?
Yes, sir.
Did you understand each of those allegations?
Yes, sir.
I'm sorry.
Yes, sir.
And are you pleading true or not true?
It's true.
And that's to each of the allegations?
Yes, sir.
Are you pleading true freely and voluntarily?
Yes, sir.
Are you pleading true because they are true and for no other reason?
Yes, sir.
Are there plea agreements in both cases?
Yes, Your Honor. Both cases, 5 years confinement, TDCJID, all balances of fees and fines are still due. And it's concurrent with the B21-128 for both cases.
You said both cases are 5 years?
Yes, Your Honor, run concurrently.
Okay, there we go. Ms. Perry, is that your understanding of each of those plea agreements?
Yes, Your Honor.
Mr. Bates, is that your understanding of each of those plea agreements?
Yes, sir.
And are you asking the court to follow those plea agreements?
Yes, sir.
In both B19-842 and B19-329, court will find sufficient evidence to enter a finding of true the state's motion to revoke. In both of those cases, will revoke your probation, will order you confined in the Texas Department of Criminal Justice for a period of 5 years, with all balances of fines and fees previously ordered still due. These two will run in concurrent with your other case. It looks like you have reimbursement fees in the amount of $200 on each case. And then you have court costs in 842 in the amount of $60. And you have significant court costs remaining in 329 in the amount of $2,918. At the bottom of each of these documents, it purports to have your time credit, which are multiple time periods that are all going to be added together to reach a total. Do you have any questions on the judgment?
No, sir.
Once you get released, can you work out a payment plan to pay off your costs?
Yes, sir. I already have a job opportunities waiting.
Wonderful. Where's your job?
In Bandera for Kenneth Welch fencing.
Okay, good. All right, pursuant to your plea agreement, the court will also sign the 2 motions to dismiss that were presented to the court. Do we have anything else to address today?
No, Your Honor.
Not from defense.
All right, thank you. Good luck to you.
Yes, sir.
Court will call cause number B21-40, the state of Texas versus Javier Viegas. For purposes of pretrial, what say the parties?
State's ready.
Defense is ready.
Do we have any pretrial issues, counsel?
None from the state.
None from the defense, Your Honor.
All right, it looks like our next scheduled appearance before the court will be November 1st for a 2801 hearing. So we'll see everybody back then. Thank you.
Thank you.
Are we gonna need Mr. Durvage, Ben?
Do we have an agreement, Lauren?
We do. We just need to get a plea date set.
Okay, you want to just do November 5th?
Yeah, that's fine.
Okay. No, I don't think, if we have an agreement, we're just going to reset. Thank you for asking.
So we're on to Mr. Mon.
If that's
We
okay
are.
with, okay, great. Sorry, Judge, I didn't want to step on your toes.
No, that's perfect. Thank you.
Okay.
So Timmons will be, I have them on, so Timmons will be after that. Timmons is waived. Okay. So it'll go from Mon to Eaton. Court will call cause number B20-451 and 452. State of Texas versus Kenneth Mon for purposes of pretrial. What say the parties?
State's ready.
Defense is ready, Your Honor. We have no motions today. In my conversations with Mr. Mon last week and conversations with the DA, I believe that we'll have an agreement. I just need to get a confirmation from my client before I say 100%. And I'll do that probably tomorrow.
you want to tentatively set it on November 5th?
Yes, Your Honor, that'd be fine with me.
All right, let's set these two cases on November 5th. We'll see everybody back then. Thank you.
Thank you, Judge.
No, he's still got the, just keep an eye on.
FYI, Judge, I'm gonna have that exact same announcements for William Ridley.
Sorry, you said Ridley?
Yes, Your Honor. Just thought I'd let you know.
I appreciate it. Well, if you want to go ahead and set him for November 5th, there's no reason to even bring him out.
I'm good with that if the state's good with it.
That sounds good to me.
Yeah, that's what he said. Okay. There he is, page 9. Yeah. There we go. Court will call cause number B20-117 and 118, the state of Texas versus Mark Eaton. For purposes of pretrial, let's say the parties.
Stacy ready?
This is
We have any-
Mrs. Molly Timmons.
Oh, Mr. Timmons.
Doesn't look like my client.
Mr. Timmons was waived.
Okay.
How about Juan Carrillo?
He was reset for November 1st. So Mr. Eaton should be your next person up.
I must not have a most recent docket. Come on.
Yeah, Eaton was in. Yeah.
I don't even see this guy. Okay. Is that the guy that only did the PDO in like 6 cases?
Judge, did we do something on page 9 with Brett Ferguson that I need to be aware of?
We did. You do not need to bring Ridley out.
Okay.
Court will call cause number B20-117 and 118, the state of Texas versus Mark Eaton.
Ridley.
For purposes of pretrial, let's say the parties.
Your Honor, I believe there are motions to proceed, and Kurt or Mr. Ruckin and I have been in discussions. This is his first appearance on this, and we're going to see if we can come to a resolution. If we could have a short reset on that. Is that correct, Mr. Ruckin?
Yes, that's correct. Mr. Rosenbach and I talked today, and I met with my client about an hour or two ago, and we're still working on it.
What we will do is tentatively set these for November 19th, and then we can move them up if we need to.
Sounds great. Thank you, Your Honor.
Thank you.
Thank you.
Is Juan Martin next?
Correct.
Yeah, Juan's in here.
Okay.
Excuse me, Your Honor. Bree West here. I just put a couple of messages in the chat. I'm logged on through my computer right now, but I needed to re-log on through my phone. I've done that, but I just need to be let in before I log off from here, if that's all right. Thank you, Your Honor. I see it now.
Court will call cause number B21-56, the state of Texas versus Juan Martin. For purposes of motion to revoke, what say the parties?
Your Honor, I'm not seeing an attorney for Mr. Martin on the docket.
Mr. Martin, do you have an attorney representing you?
I had it on this case. It was Ted Witzke.
Was that on the motion to revoke or the original case?
The original case, but I don't
Okay,
know.
what you need to do is fill out an application for court-appointed counsel so that we can reappoint you an attorney.
Okay.
The motion to revoke is basically a whole new case.
Okay. So I would have to, okay.
Yeah, fill out the application for court-appointed counsel, and then we'll get you back before the court on November 1st, okay?
November 1st, okay. I'll do that.
Thank you.
Thank you.
Mr. Hines is next.
Yes.
Mr. Ferguson, on Mr. Hines, I'm showing a whole stack of motions inside the court's file
Yes, Your Honor.
that I've never seen. when you file those types of motions, if you would forward a copy to Christine, it'll greatly expedite things.
Most certainly, Your Honor, I will.
Court will call cause number B21-233, the state of Texas versus George Hines. For purposes of pretrial, let's say the parties.
It's ready.
Defense is ready, Your Honor. We have filed several motions for the court to take into consideration.
I'm not ready for those motions. I don't recall it being served with them, but are they contested or what are they?
Well, I've got a motion for an expert witness that can discuss DNA and the likelihood of an improper DNA test. They would be able to discuss the potential for tainting of DNA testing, just whether, accuracy matters of all of the DNA testing that was done in this case. We have a motion for an investigator, an independent investigator for our side, a motion for an independent exam of the DNA to have it all reevaluated by our own expert, a motion to discover all of the arrest records and conviction records of the witnesses for the state, motion in limine, which of course could be handled prior to trial, motion to require the state to reveal any agreement with the witnesses.
Let's do this. All your contested motions, let's set all those for November 19th. And then the other motions that are for experts, make sure I have orders on those, please. Because I'm just looking through here and I don't believe there's orders in the file.
I usually file orders with my motions, but if not, Your Honor, I'll make sure I get them up there today.
Okay. All right, we'll set all the contested motions for November 19th.
Thank you, Your Honor.
You're welcome.
Did you hear that, George? Did you understand that? George?
Yeah, I heard it.
Okay.
I don't know. I don't have everybody showing on mine. I don't know. Send her chat now. She's in Pulling Lewis's. Yeah. Court will call cause number B21-383, 384, 385, and 386. State of Texas versus Brandon Lewis. For purposes of pretrials, let's say the parties.
The defense is ready, Your Honor. We do not have labs back on it yet, though.
State's missing in action.
Sorry about that. Sorry about that, Your Honor. I was muted. We're ready, and that is correct. Mr. Winsky's said that we're still waiting on labs, and that's correct. We're waiting on labs.
All right, let's tentatively set the pretrials for December 13th, and if we get our lab sooner, then let's jump on the earlier docket, please.
Sounds great. Thank you.
That works, Your Honor.
Thank you.
Is Jesse Irving next?
Yes, ma'am.
Judge Rafael Leal is in that capital punishment trial on Mr.
Okay.
Irvin.
Can you hear us in the jail? Nope.
Sorry, I was slow on the draw.
Okay. Yeah. Hey, Mr. Irvin? Mr. Irvin, can you hear me?
I can.
Okay, your attorney is tied up in a capital trial and he cannot be here today. So what we're going to do is reset you for November 1st
Okay.
when he can be present, okay?
Okay.
Thank you, sir.
Luis Garcia?
Yes, ma'am.
Luis Garcia? Luis Garcia?
Oops.
Nope.
Court will call cause number B21-461 and 462, the state of Texas versus Luis Garcia. For purposes of arraignment, what say the parties?
State's ready.
And defense is not ready for arraignment. I think one of these is arraignment, the others are pretrial. Is that correct, Ben?
I believe two more arraignments and, or I'm sorry. I don't know where my thing, oh, there it is.
It's showing arraignment on both of them.
It's, yeah, I believe it's arraignment on both of them, Dave, but the deal is I think we've come to an agreement, a tentative agreement, and we were gonna reset that, correct, Dave, for a plea? Or-
That's correct. I have an offer I've got to relay to my my client. I'll waive arraignment and bring the offer to my client, and hopefully we can come back in November, I think the 5th, and get this resolved.
Yes, he's already on probation and these two new cases came down, and so we're just getting them resolved, Your Honor.
All right, we will reset both cases for November 5th for a plea, but In the event that that doesn't happen, if you would, will you please forward written waivers of arraignment?
Yes, sir.
All right. We will see you back November 5th, sir. Thank you.
Are you working?
Before that. Court will call cause number B20 169 and 170, the state of Texas versus Devin Pineda. Mr. Pineda, I'm assuming you're aware of the fact that your attorney is deceased.
Yes, sir.
Okay. And have you made any effort at all to find another attorney?
My mom and my grandma are working on it. My mom said she's going to the public defender's office when she has a chance, but she's always working. So I don't really know what's going on right now.
Okay. What I'm going to do is reset you for November 1st, okay?
Okay.
And we'll bring you back before the court. But if you're going to apply for a public defender, you need to ask them at the jail to give you an application for court-appointed counsel.
Okay. All right. Thank you, sir.
All right. We'll see you back on November 1st. Thank you.
Thank you.
Court will call cause number B21 227 and B21 534, the state of Texas versus William Lebron. On B21 534, let's start out with that one for purposes of arraignment. Mr. Ellison, have you had an opportunity to go through the indictment with your client?
Your Honor, I'm sorry, I stepped away.
That's okay. This is Mr. Lombrana. And on B21 534, it's set for arraignment. Have you had an opportunity to go through the indictment with your client?
Yeah, yes, Your Honor, and we'll waive formal reading and enter a not guilty plea.
And the personal identifiers are true and correct to the best of your knowledge?
Yes, Your Honor.
All right, the court will enter a scheduling order in this case.
Yes, Your Honor.
Now, B21-227, for purposes of pretrial, do we have any pretrial issues to address?
Not from the defense, Your Honor.
None from the state, Your Honor.
All right, let's set pretrial on December 13th so it'll run the two cases simultaneously.
Yes, Your Honor.
See everybody back then. Thank you.
Thank you.
Yes, sir, thank you.
Yep. So it'll be an interesting argument. Well, ready, Paul? Court will call cause number B21-472 and 473, State of Texas versus Demacio Sandoval Jr. For purposes of pretrial, what say the parties?
State's ready.
Stella Puente Chacon on behalf of Demacio Sandoval. Your Honor, we're not ready as far as pretrial is concerned. I'm still missing some discovery from the state. I received the copy of the medical examiner's report and it's incomplete. All the pictures are missing and I'm still missing some lab reports in the discovery. It is a murder case, so it is extensive and I understand there's a backlog with labs right now and things like that. So we would ask to reset the pretrial. And I also have a motion to reduce bond pending under the two cause numbers that were scheduled for today that we had an order signed to hear it today, Judge. And we are ready to proceed on that.
Thank you.
And I'm ready on that. I've got it. We're ready, Judge.
Okay, let's proceed on the motions to reduce bond.
Yes, Your Honor. I have two witnesses and they're together on Zoom. They're under one device, Judge.
Which device?
The name on the screen, Judge, is Silvia Romero.
Okay. I don't know who's in charge. Will you please unmute yourself? Ladies, you need to unmute your device, please.
Ms. Romero, can you hear? Please unmute the device. You're on mute.
There we go. Can each of you please raise your right hands? I think they're frozen.
Yes, I think there's a delay on their end.
Can each of you please raise your right hands? Do you have a phone number to call them?
Yes, Judge, I do.
Call them up and ask them to please log out and log back in.
Yes, Judge, I will. Please give me a minute. There.
That's fine. She's wearing it. How I'm gonna log out. Leave. Hello.
Fix the AC while we're dead in the water. Paul, if you're cold, go turn the AC on.
I advised her, Judge. She's logging. She already logged out. I believe she's gonna log back in.
Thank you.
Hey, while we're waiting, if you'll send me a list of the stuff that you feel like you don't have, we'll do what we can to make sure you get it as promptly as possible.
Yes, Mr. Harpo, will do. I'll get you that.
Okay.
Thank you.
Oh, yeah, no.
Judge, I believe they're in the waiting room. Do you see them?
Theoretically, they're joining us.
No, stop here. We're gonna go to Overguard.
Okay, I see them on, Judge.
Ms. Romero, can you unmute, please? All right, ladies, can you please raise your right hands?
There.
In the matter before the court, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Cohen, this is never going to work. You're going to have to get them to a location where they have better cell service or something.
Yes, Judge, and I'm assuming that you want them to appear on video, right, Judge, instead of them calling in?
Correct.
Okay, let me find them to get better cell service, or does the court have, let me see if I can get them to do that now.
Okay, and we'll circle back.
Thank you, Judge.
Thank you.
Yes.
All right, can we go ahead and jump to Ricky Calvert, please?
Yes, sir.
Hold on, go to these two files. Yeah, no, it's waived, or she's gonna waive it. Got an order with no motion. And no signatures. We are moving slower than the last was in February.
I don't have one. I took it when they,
Court will call cause number B21-376, State of Texas versus Ricky Calvert. For purposes of pretrial, what say the parties?
State's ready.
Judge, defense is ready too, although it is my impression as of today that Mr. Calvert may have retained Ms. Perry.
I don't know. I have an unsigned order with no motion, so I'm not sure where we stand.
I emailed Ms. Perry while we were on Zoom because I was just looking at his file on Odyssey and I had no knowledge of that. But
well, Mr. Calvert, have you retained Ms. Perry?
yes, sir.
And Judge, I have filed my motion for substitution and I have a file stamped copy. I'm not sure why you didn't get it, but.
Yeah, it's not in the file either. Okay. Well, any objection, Mr. Stevens?
no, Judge.
All right, for purposes of pretrial, let's say the parties.
State's ready.
Defense ready?
Do we have any pretrial issues?
Not at this time, Your Honor.
Not from defendant today.
All right, the next scheduled appearance, do we have any lab test results?
I believe,
Judge, I mean, I can tell you that as of last week, when I spoke to Mr. Rosenbach, we didn't have any.
that's correct. Still don't.
All right, let's reset for December 13th, and if we receive our lab results, then we'll jump in sooner.
Thank you, Judge.
Thank you.
And I'll be able to get the discovery even though it's already been provided to someone else.
Well, why don't you work with the other counsel to get a copy to file?
I'll do that.
Ms. Perry, I'm happy to talk to you this afternoon about that case.
Thank you, sir.
Sure thing.
Bye. May I be excused, Judge?
You may. Thank you.
Thank you. Bye.
Okay.
Where are we at on here? I'm showing McKee was continued. Yeah. Curtis Roberts.
Judge, on Mr. Roberts, it's my understanding that both of these cases have been transferred to the 216th.
Well, we don't need to waste time on them then.
That's
Thank
correct.
you. Thank you for telling me.
No problem.
Court will call cause number B19-819, the state of Texas versus Shane Wesh. For purposes of pretrial, what say the parties?
Judges,
ready.
Roberts,
All right, Roberts apparently has been transferred to the 216th. So we don't need him anymore. And the next one on the docket is Shane Wesh.
William, both of your cases here have been transferred to the other court. I'll be working with you in that other court on those cases all together, okay?
Yes, sir.
come on.
Thank you, Joe.
Those guys are sitting so far back, I can't identify them. There we go. Court will call cause number B19-819, the state of Texas versus Shane Wesh. For purposes of pretrial, what say the parties?
State's ready.
Defense is ready, Your Honor.
Do we have any pretrial issues, counsel?
None from the state.
Your Honor, I did have a question. One of our witnesses is out of state in Illinois. Are we allowing for our witnesses to testify by Zoom, or do we need to have them in person, particularly if they're situated neutrally? It's an insurance adjuster who has no game in this.
Judge, my response would be, first off, would be that I would be objecting to that witness testifying anyway. But if the court were to deny my objection, I would request her presence and not participate by video.
All right, does that answer that for you, Bob?
Well, if Mr. Harpo takes that position, I understand. We are going to issue a subpoena. We've got to issue other subpoenas. Hers is out of state. It's complicated because we've got to, go through her corporation, Liberty Mutual Insurance. Can we at least get a heads up as to where we sit on the trial docket? And when we get our setting, whether the state, can ascertain whether we're going to be, near the top and whether we need to be ready. We're ready. That's not the issue. The only issue is trying to save the family money from that subpoena and just issuing other subpoenas when, we're just costing the clerks a lot of time, wasted time. That's my only issue.
Well, it doesn't sound like you're ready, but in any event, Judge, I don't know when the next trial setting is, what we've got coming up and what's stacked or not. I would think that November is pretty crowded. So
I'm showing back in August, he was set for November 1st for pretrial, November 2nd for trial.
Oh, I see. Well, Judge, I would say that in light of the trial that we're having for, right tomorrow and into next week, that trial be reset to January.
And Your Honor, if I may just very briefly, for the November 2nd trial date, Mr. Ferguson and I had a trial that was specially set, and then it got moved to November 2nd to be number 1 because his client was in the hospital for COVID. And so that November 2nd date, we're planning for Mr. Ferguson's client, Richard Dino Gonzalez Jr., to be the number 1 and only case to go on that November date. So I just wanted to
heads up. Thank you, Ben.
But that's just Mr. Ferguson is aware of that, and that was a specially set case. So
Yes, sir.
Is there any reason y'all know of off the top of your heads if we can't make Mr. Wesh #1 on January 4th?
I don't have a problem with that, Judge.
No, sir.
All right. Let's set a pretrial on January 3rd and trial on January 4th. And if you have any contested motions or anything we need to address before then let's slip it in on one of the other dates.
Yes, sir.
Sounds like a plan.
Okay.
Sure.
Thank y'all.
May I be excused, Your Honor?
You may. Thank you.
Thank you, Judge.
Judge, I believe whenever you get a chance, I believe the witnesses are on a device that is working now.
Court will call cause number B20-197 and B19-528, 529, and 909. State of Texas versus Clay Roberts. For purposes of pretrial, let's say the parties.
State's ready.
Defense is ready, Your Honor.
And I guess the first question I need to ask is, have we received the results of the competency exam?
We did, Your Honor.
And we are competent to proceed, correct?
He is, Your Honor.
All right, do we have any pretrial issues we need to address?
No, Your Honor, Ms. McCollum and I were speaking about these cases this morning. So we just need a little bit of time to see if we can resolve it, given that he has just come back competent to stand trial. Is that correct, Ms. McCollum?
It is, Your Honor.
All right, let's reset for December 13th, and then we'll come up with a plan on that date.
Thank you very much.
Thank y'all.
Excuse me, Your Honor. Mr. Emerson.
Yes, sir.
Can I just bring to your attention that these cases have been on the docket for 29 months and I've been in jail for 21 months with no bond. I just wanted to bring that to your attention. And 3 of my cases only carry a 24-month sentence.
Talk to your attorney when he comes to see you, okay?
Thank you.
When she comes to see you, excuse me.
Thank you.
Are we on to Mr. Brown, or are we going back to Mr. Sandoval?
We're on to Mr. Brown.
Thank you.
jump back when we get to the bottom of the page. Court will call cause number B 21-136, 137, 138, 139, and 140. State of Texas versus Charles Brown. For purposes of pretrial, let's say the parties.
State's ready.
That's right.
Do we have any pretrial issues, counsel?
No, Your Honor, the only issue that I have is at this point, I don't believe anybody from the state has reached out with any type of possible negotiation on this. So I was hoping that could happen soon. That way I can advise my client if there's any type of possibility for a settlement.
Charles Bradley,
I don't have anything from you yet, Ben, about it.
okay. Well, then we'll get together and do some work.
Okay.
All right, let's reset it for December 13th, and then if y'all decide we need to get back to the court sooner, we can certainly add it to the docket.
Okay, thank you, Your Honor.
You're welcome.
Thank you.
Docket shaping up to be a little later. Well, it's stacked and it's right behind this jury trial and in front of the next one. So. Can you hear me in the jail? Nope. I think I set it for December, didn't I? Court will call cause number B 20-302, the state of Texas versus Jacob Overguard. For purposes of pretrial, let's say the parties.
State's ready.
We're ready, Your Honor.
We have any pretrial issues to address?
Your Honor, I have a motion to withdraw because I'm trying to wind down my court-appointed cases, and this is a very serious one. It's allegations of continuous sexual abuse and child porn. It's going to probably take a couple of years and be very, very intensive.
Your Honor, also, I think that what was missing out is that Mr. Overguard and the other client that Mr. Ellison has, Lambrana, share the same victim.
Oh, Lord, I didn't even know that.
So I think he's conflict.
That's a new one for me.
Okay. The court will grant the motion of withdrawal. And what I'm going to do is tentatively appoint the public defender's office.
Your Honor, with this new information, I will be filing a follow-up motion on Lambrana, but to withdraw for him as well.
Okay, thank you.
Yes, sir.
All right, Mr. Overguard, I'm going to appoint the public defender's office. I'm going to reset your case for December 13th. That will allow them time to get their hands on your discovery and have some idea of what you're looking at, and then they'll be out to visit with you shortly, okay?
Yes, sir, sounds good.
Thank you.
Yes, sir,
Thank you, Your Honor.
This one? Okay, they don't have a conflict now. Okay. Okay, well, if they do, they'll file. This one set for trial tomorrow too.
Understand, have been fortunate enough. Okay.
If you can hear me in the jail, we will bounce back to Sandoval after Naji Ray, please.
Yes, sir.
Court will call cause number B18, 882 and 883, the state of Texas versus John Ellis. For purposes of pretrial, let's say the parties.
State's ready?
The defense is ready, Your Honor.
Do we have any pretrial issues?
None from the state, Your Honor. We've been in plea negotiations this morning, and there's some legwork that we need to take care of, but other than that, no pretrial issues from the state.
And no pretrial issues from the defense other than just Mr. Rosenbach has a few phone calls he's going to make on this case.
So I assume we're all passing the trial setting for tomorrow?
Correct.
Yes, sir.
All right, let's set it on pretrial for November 1st, and then we can figure out where we stand from there.
Yes, sir.
Sounds good. Thank you.
All right, Mr. Ellis, we'll see you back November 1st. Thank you.
Thank you.
He's old. Gotta get the trial. November 1st. Court will call cause number B19, 876, 877, and 878. The state of Texas versus Naji Ray on. It looks like on B19, 878, we have a 2801, and the other two cases will be a pretrial. Do we have any 2801 announcements or motions in this one case?
None from the state, Your Honor.
None from defense, Your Honor.
Any other pretrial issues we need to address in this case?
Not this time, but kind of the same announcement as the last defendant. We just need to do some follow-up and then get these cases resolved one way or the other.
That is correct, Your Honor. We've conferred for quite a long time this morning on these.
All right, and no pretrial issues on the other two cases?
That's correct.
All right, we'll see everybody back on November 1st and then figure out how to proceed from there.
Mr. Perry, to you.
I will come by the jail. I have some time tomorrow afternoon. I'll come see you.
Okay, I got family emergency coming on. Family emergency, I really do need to talk to you about.
Yes, sir. I'll come by tomorrow afternoon and talk to you.
Thank you.
Thank you.
Okay, we're going to bounce back to Sandoval next. While we're waiting on Sandoval, I'm looking at the docket entry. I'm not sure. Do we even need to bring Travis Nolan out, or were these all waived?
Your Honor, I believe we waived them all on Friday afternoon. If we could just reset him to November 5th for a plea, we have a plea worked out for him.
Okay, and that's on all 6 cases?
Yes, Your Honor.
That's correct.
We can do that.
That works.
Okay, let's see here. There we go.
Judge, further down the docket, you also have a Roland Reyes who has been waived today. I just wanted to let the court know that he is out of custody. So whatever date he was given, which I believe was 11/1, just to make sure that would be at 8:30 and not at 1:30.
I'm looking for him. Roland Reyes.
He was waived last week. He was taken off the docket. I didn't know which docket.
Yeah, I don't see him on there.
Okay, no problem.
Hang on, those. Thank you. All right, we're back on the record in cause number B21-472 and 473, the state of Texas versus Demacio Sandoval Jr. And I believe we were set for a bond hearing. And ladies, you're unmuted now. Can each of you please raise your right hand? In the matter before the court, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Oh, not again.
Can you raise the volume, ladies? And speak loud and clear so we can hear you?
Okay. Did you hear the court swear you in? Their microphone's not on or something.
No, I don't know. I don't know if they connected to audio either, Judge. I can't see like the little microphone. Judge, can they stay on the screen and call in using from their phone and we can hear the audio from their phone? And do a live video?
It's not going to be possible for anybody else to hear them. That's the problem.
If we have.
We're not that sophisticated on this end.
Oh, I get you. Because I was going to say they can stay on the screen like the way they are and then use their phone so you can actually hear their testimony. Just a suggestion.
All right, let's try circling back to Sandoval again in a few minutes.
Yes, Judge. Thank you.
Can we go ahead and pull Devin Geller, please?
Devin Geller?
Yes.
Yes, sir.
Geller? No. I- Stop that.
Hello.
Hello.
Having a good day, Judge.
And the court will call cause number B19 640, 641, and then B21 297, 298, and 299, the state of Texas versus Devin Geller. A couple of them are motions to proceed. The others are pretrial, but probably the first issue we need to address that I just saw is the motion for competency evaluation. Has that previously been addressed that you're aware of?
Judge, I don't believe so. And you're exactly right. The top two are motions to proceed. The bottom three are newly indicted cases. So the motion, it's a combined motion for incompetency and an insanity assessment. And they would be pertinent to the bottom three, the most recently indicted cases. I don't believe an order has been signed, Judge.
Mr. Harpold or Mr. Rosenbach? I'm not sure who's going to take this on y'all's side.
Well, I've been in conversation with Mr. Stevens about this motion. I reviewed the motion. I mean, the competency is typically what we already agree on, but the insanity is a defense. And so I'm not exactly sure. I don't want to put don't want to put words in Mr. Stevens' mouth, but happy to get somebody evaluated for competency, but the insanity thing, I'm a little bit.
Judge, Mr. Rosenbach is correct, and it's indeed true that 9 times out of 10, it's a competency evaluation. In the case where insanity may be raised as a defense, it is appropriate under the code to have that assessment done under one doctor's visit rather than separate the two. One cannot, one could be technically found insane by a doctor's order, but that defense may not hold a trial. So it's similar evaluations, and I just think just for the nature of having the assessment done thoroughly, to do it in one combined visit rather than to go through the competency and then the insanity route.
Okay. Court will order an evaluation for competency and insanity with Dr. Wood. And let's set another pretrial on December 13th and see where we stand on these.
Sounds good. Thank you, Your Honor.
Thank you, Judge. Judge, that does it for me today. May I be excused?
You bet. Have a good afternoon. Thank you.
Yes, you as well. Thank you.
Judge, we didn't need Travis Nolan or Sergio Lugo today.
Correct.
Okay, so we're on to Mr. Lucero.
Yes, ma'am.
Thank you.
You want to try? You want to go after this one? Since we're at the bottom of the page. All right, the court will call cause number B21 468, 469, and 470. State of Texas versus Abel Lucero. For purposes of pretrial, let's say the parties.
Seats ready?
Defense is ready, Your Honor.
Do we have any pretrial issues, counsel?
None from the state.
None from the defense at this time.
All right, our next scheduled appearance before the court is on November 1st for a 2801 hearing. So we will see everybody back on November 1st.
Great.
Is there any motions that were put in?
I'll come talk to you on Wednesday, Abel.
All one I have is the other one. All right, ladies and gentlemen, let's take about a 5-minute recess and then we'll bounce back.
Okay.
Sit down. Yes, ma'am. Is it taking a break?
Order, please.
We got reset or what?
I guess I wasn't in there. You just asked for Geller.
Attorney visit for visitation two.
You doing all right today, Mrs. Minerva?
I am doing fine.
Day's almost over, huh?
Mm-hmm.
Court will call cause number B21, 346, 347, 348, and 349, State of Texas versus Jordan Kier. For purposes of pretrial, let's say the parties.
Stacy ready?
Defense is ready.
Do we have any pretrial issues to address?
None from the state.
None from us at this time, Your Honor.
All right, it looks like our next scheduled appearance is November 1st for a 2801 hearing. So we'll see everybody back in a couple of weeks. Thank you.
Thank you.
Court will call cause number B21-131 and 132, the state of Texas versus Matthew Iverson. For purposes of pretrial, what say the parties?
State's ready.
Defense is ready.
Do we have any pretrial issues, counsel?
None from the state, Your Honor.
None from the defense, Your Honor.
Give me just a moment. All right, let's set a 2801 on November 1st. So we'll see everybody back on November 1st for a 2801 hearing. Thank you.
Matthew, I'll come see you tomorrow.
Okay.
All right, thanks, man. Your Honor, that's all I have. May I be excused?
Absolutely. Thank you.
Thank you. Have a great day.
Wait, hang on. The next guy up is yours too, David.
You're right. You're right. I have one more.
Trying to sneak out with half the inning left to go.
I was trying.
No.
We'll call cause number B20-359, 360, 361, and 362. State of Texas versus Aryan Orning. For purposes of pretrials, what say the parties?
It's ready.
Defense is ready as well.
We have any pretrial issues, counsel?
None from the state. He has 4 new failure to appears that are set for arraignment on the 1st of November. So we can put all these cases together. I think that would be prudent.
I agree with that, Your Honor. There's no pretrial issues at this time. We'll confer and maybe get a resolution to most of this.
All right, we will set these 4 pretrials for November 1st to coincide with the other 4 cases. Thank you.
Thank you, sir. Your Honor, I think the inning is over. May I be excused now?
You may.
Hey,
Thanks, David.
have a great day.
You too. We're not doing it. Oh, I did. Got too many stacks of cases. Sorry. While they're bringing Mr. Brandt out, do we have our lab results yet?
Yes, in the in 19807, I think 807, 808, and let's see, 21288 no labs for 21-288, and then he has two new cases that are coming down the pipe that are going to be set for indictment here at the next grand jury.
Okay, thank you. Court will call cause number B19-807 and 808 and B21-288, State of Texas versus Kevin Brandt. For purposes of pretrial, what say the parties?
State's ready.
It's ready, Your Honor. We have no motions today. In my negotiations with the state on Friday, actually, they have given us some new plea offers. I need to go over those with Mr. Brandt. I'm not confident in the offers, but I'm going to discuss it with him, and then we'll go from there.
All right, we will set the next pretrial for December 13th, and by then we should have the disposition of the new indictments, if in fact they're coming.
Thank you.
Okay, thank you all.
I'm gonna try and come and see you in the next couple days, okay, Kevin?
Yes, sir. Sounds good. Thank you very much.
All right, have a good one.
Yes, sir. I'll try.
Tomek's a plea, is that correct?
I believe so.
Yes, Your Honor, he is.
Do what? Court will call cause number B20-579, State of Texas versus John Tomek. For purposes of agreed pleas, what say the parties?
State's ready.
State's ready, Your Honor.
First document we need to go through is the joint request for plea or sentencing by video conference. It purports to be signed by each of the parties. Mr. Tomek, do you have any objection to proceeding today by video conference?
None at all, Your Honor.
Thank you. The next document we need to go through, counsel, is the 3914 Discovery, Disclosure, and Compliance Form on each of these counts, each of which purports to have each of your signatures. Is that correct?
That's correct.
That is correct, Your Honor.
To the best of your knowledge, has the state received all the discovery from law enforcement and forwarded the same to the defense on each count?
Yes, Your Honor.
To the best of your knowledge, have you received all the discovery on each count?
Yes, I have.
Is there any objection to going through the admonishments together?
No objection.
No objection from the defense.
Mr. Tomek, I'm showing you one document, but in fact, there are two. Each of them is titled Defendant's Plea of Guilt, Waivers, and Admonishments. Did you have a chance to go through each of those documents with your attorney?
Yes, I did, Your Honor.
Did you understand each of those documents?
Yes, I do, Your Honor.
Do you understand in both counts you have a right to a trial by jury?
I do, Your Honor.
In both counts, you have a right for your attorney to cross-examine the state's witnesses and to call your own witnesses.
I do, Your Honor.
And in both counts, you have a right to appeal.
Understood, Your Honor.
Do you understand that you're waiving all three of those rights in both counts today?
I am, Your Honor.
In addition to that, do you understand that you have a right to remain silent? Nobody can require you to testify against yourself, but you can in fact waive that right.
Understood.
Page 3 of each of these documents purports to have your signature in two locations. Do you recall signing each document twice on page 3?
Yes, Your Honor.
Your second signature on each one appears below a paragraph entitled Judicial Confessions and Stipulations. Do you understand that by signing that paragraph, it's just like you stood up here before the court, raised your hand and said, I did what the state's accused me of doing?
I do.
Attached to the back of each one of these documents marked as State's Exhibit A is a copy of the grand jury indictment. It purports to have your signature at the bottom. Is that your signature?
Yes, it is, Your Honor.
And are you asking the court to accept as true and correct this grand jury indictment?
I am, Your Honor.
Do you feel like your client understands his rights, waivers, and admonishments of both counts?
Do, Your Honor.
The next document we need to go through in both count 1 and count 2 is the agreed stipulation of evidence and waiver of testing. Purports to have your signature on it. Is that your signature?
Yes, Your Honor.
Did you have a chance to go through this document with your attorney?
Yes, Your Honor.
Did you understand this document?
Yes, Your Honor.
You understand that by signing this document, you're waiving your right to have the evidence tested, and you're stipulating that it is what the state says it is.
Yes, Your Honor.
Do you feel like your client understands his agreed stipulation and waiver?
I do, Your Honor. We went over it very explicitly.
In B-2579 count 1, you've been charged with possession of a controlled substance in penalty group 1, to wit methamphetamine less than 1 gram. This is a state jail felony. In B-2579 count 2, you've been charged with possession of a controlled substance in penalty group 1, to wit heroin less than 1 gram. This is also a state jail felony. In each of these counts, the range of punishment is from 6 months to 2 years confinement and up to a $10,000 fine. Do you understand the charge and the range of punishment on both count 1 and count 2?
Yes, Your Honor.
And as to count 1, how do you plead?
No contest.
He's no contest. Mr. Ferguson?
I'm sorry, I didn't hear what he said.
He pled no contest.
Mr. Tomek, in the no contest that we discussed, that was in the misdemeanor case.
Okay.
Here in the felony court, we're going to plead guilty, okay? I'm assuming you still want to.
Yes.
I assume you do.
Got it. Mistake.
Okay. Let me ask you again, Mr. Tomek, in count 1, how do you plea?
Guilty, Your Honor.
In count 2, how do you plea?
Guilty, Your Honor.
In each of those, are you pleading guilty freely and voluntarily?
Yes, Your Honor.
In each of those, are you pleading guilty because you are guilty and for no other reason?
Yes, Your Honor.
And are you a citizen of the United States?
I am, Your Honor.
Do you feel like your client's competent and capable of assisting you in preparation for trial?
I do, Your Honor.
Are there plea agreements on both counts?
Sorry, Your Honor. So it's 2 years confinement, state jail, probated for 3 years. The LTIP course. In count 1, there's a $2,000 fine. There's no fine in count 2. Drug alcohol treatment per probation office.
Ferguson?
Yes, Your Honor, that is my understanding of the agreement. And for in the court, on the back of the plea documents, there is a letter from Hatchery House, which Mr. Tomek has already been accepted into. And I have not provided a copy to the DA's office, but I will do that as we sit here. I forgot to send it over to him.
Thank you.
Just a letter for information.
Okay.
Mr. Tomek, is that your understanding of both plea agreements?
Yes, Your Honor.
And do you understand that plea agreements are agreements between you and the state? They're not binding on the court, but if the court did not accept either one of your plea agreements, you'd have the opportunity to withdraw your pleas of guilty, enter pleas of not guilty, and proceed to trial.
Yes, Your Honor.
And are you asking the court to follow both plea agreements?
Yes, Your Honor.
In both count 1 and count 2, the court will find evidence beyond a reasonable doubt to enter a finding of guilt. Pursuant to your plea agreement, in each count will order you confined in the Texas Department of Criminal Justice State Jail Division for a period of 2 years. We'll probate that for a period of 3 years. You must successfully complete the Life Training Institute program. If ordered by probation, you must attend the drug and alcohol treatment program. In count 1, you have court cost in the amount of $290, reimbursement fees in the amount of $85, and you have a fine in the amount of $2,000. Do you have a question on either one of those judgments?
No, Your Honor.
Attached to the back of each judgment is an order granting community supervision. Did you have a chance to go through both of those orders with your attorney?
Explicitly, Your Honor.
Did you understand both of those orders?
Yes, I did, Your Honor.
Do you understand those orders contain all your terms and conditions for probation?
Yes, Your Honor.
Do you understand your terms and conditions of probation include a $60 per month probation fee?
Yes, Your Honor.
Do you understand that there's a one-time $50 Crime Stoppers fee that's due in each count?
Yes, Your Honor.
Do you understand you're subject to random urinalysis and drug tests at your own expense?
Yes, Your Honor.
Do you understand that you're agreeing to a search of your person, your place, your residence, your vehicle, or any electronics to ensure conformance with the terms and conditions of probation?
Yes, Your Honor.
Do you understand you must successfully complete the Life Training Institute program?
Yes, Your Honor.
Where do you work?
I'm going to school full-time, Your Honor. I'm retired military.
Where are you going to school?
I will be working with Hatchery House, the owner of the Hatchery House for painting, as soon as I get there.
I'm going to put all your community service in one count. On count 1, you have 200 hours of community service. Work with the probation department so they can work around your school or your job.
Roger that, Your Honor.
Do you have any questions at all on your terms and conditions of probation?
No, Your Honor.
All right, good luck to you, Mr. Tomek.
Thank you, Your Honor.
I'm Mr. Tomek. Mr. Tomek.
Sure.
Those misdemeanor issues have already been taken care of. I've already got the judgment back. So when you come in either later today or tomorrow morning, I'll have a copy for you, okay?
Thank you.
And sir,
Thank you. Oh.
just a minute. I need you to report to probation when you get released, okay?
Right.
Right across the parking lot.
Thank you.
Thank you.
Court will call cause number B20-126, the state of Texas versus Travis Martin. For purposes of pretrial, what say the parties?
State's ready.
I'm here, Your Honor. We're ready.
We have any pretrial issues to address, counsel?
Not from the defense, Judge.
All right, it looks like our next scheduled appearance before the court will be November 1st for a 2801 hearing. So we'll see everybody back in a couple of weeks. Thank you.
Yes, Your Honor.
I have Gonzalez. Ridley, I'm showing is reset. So I need these. No, Ridley's reset. Does Latrell not have an attorney? He's been incarcerated ever since then?
Huh. Overguard.
Rick, you're not. I was going to tell you that you weren't on mute and we could hear you.
You hear me mumbling and cursing? I'm sorry. Thank you for telling me. Jesus. It's what I get for reading emails while I'm doing this. Thank you.
Please mute yourself.
It's been a long day.
Judge, I'm waiting on Mr. Gonzalez. I have Mr. Deese, I have Mr. Latrell, and I have Mr. Ballard, if you want to go to one of those.
Sure, let's pull up Mr. Deese.
Okay.
Good morning, or I guess it's afternoon now, isn't it? Almost evening.
It is.
Hi, Judge. How are you?
I'm good, and you?
I'm doing well, sir. Thank you.
How's the big city of Fort Worth?
Well, I'm in the bigger city of Dallas, and it is
Okay.
wonderful, as always.
Well, it was close. I knew you were up that direction somewhere.
Yeah, that's right. That's right. Although, you know, Dallas and Fort Worth, we're very different. Although we're close, we're very different.
That's true. Have you talked to the DA about getting a new trial date?
At the time that we spoke, Your Honor, I don't know that he had the dates in front of him. So we didn't discuss the actual date. But I do know that there is a case proceeding starting tomorrow. So I know that we're getting bumped. I did also send him a request to consider a plea. I think it's been rejected, but I did try.
Ready, Paul? Court will call cause number B20-177, the state of Texas versus Troy Deese. For purposes of pretrial, let's say the parties.
State's ready.
The defense is ready, Your Honor.
Do we have any pretrial issues, counsel?
None from the state.
And nothing other than what's already been filed by the defense, Your Honor. I think that the court determined that I think it ruled on most things. There were other things that were going to be taken up at a later time, and I don't think that this is the appropriate time for those things. So at this point, not right now from the defense.
Okay. Then let's set a pretrial on November 1st, and that'll give you and the DA a couple weeks to talk and maybe try to figure out a plan of strategy for when we're going to get this case to trial.
Thank you, Your Honor. We're looking forward to it.
We will see you back November 1st. Thank you.
Okay. Thank you. Mr. Dees, I'll talk to you soon. Your Honor, may I be excused?
Yes, ma'am. Thank you.
Thank you. Talk to you soon. Bye, Mr. Harpold.
Thank you. Somebody else. Maybe they'll bring the trail out next.
Hey, Ben. On that
Brett.
letter from Hatchery House, I cannot find my copy of it. I thought I'd actually scanned it into the computer, but it's in the court's file. I can get a copy and forward to you if you would like.
It's whatever. It's not that big of a deal.
Huh?
It's not that big of a deal.
Okay, it's just a basic letter that, you know, we've seen a million times.
Yes, sir.
Judge, this is Mr. Ballard.
Thank you. Okay, can I have Ballard's file? We're jumping like 3 down. Can I have Luttrell next, please?
Most definitely. It was a toss-up.
Thank you. Sorry. Court will call cause number B21-315 and 21-487, State of Texas versus John Ballard. For purposes of pretrial, let's say the parties.
It's ready.
The defense is not ready, Your Honor. We have an agreed order signed by myself and Ben and yourself, Your Honor, for a competency evaluation. The evaluation is to take place no later than November 20th, with the report being generated no later than December 5th.
Okay.
Well, let's see if we can get everybody back in on December 13th, and maybe we'll have our results by then.
Your Honor,
Yes.
can I speak?
Mr. Ballard, I'm going to come see you right after this.
Well, I'd like to get a PR bond if that's possible.
We'll see you back on December 13th. Thank you.
Yes, Judge. Thank you. And that was all I have for you, Judge, today. May I be excused?
Absolutely. Thank you. Appreciate it.
Your Honor, I think I'm done. May I be excused?
Absolutely. Thank you.
Yes, sir. Thank you.
Lauren, are you still with us?
I am, Your Honor.
Okay. I don't know if you'll get this case or somebody else in your office, but the next guy coming up, I'm going to appoint the PDO. He's been in jail a while. I think he's homeless just from looking in the file. And he didn't have an attorney prior to this because he refused to complete the application.
Okay, is that Luttrell or is that?
It's Mr. Luttrell.
Okay.
Court will call cause number B21-531, the state of Texas versus Charles Luttrell for purposes of an arraignment. Mr. Luttrell, you're not represented by an attorney, are you?
No.
Okay, what I'm going to do is I'm going to go ahead and appoint the public defender's office to represent you. And then I'm going to reset your case for November 1st. So they have time to come out there and go through the indictment with you. And then we can present back in court so that you understand what you've been charged with, okay?
I know that the patrolman
Don't say
was
anything
looking
about
at
your case.
another patrolman talking to someone. That's the last thing I remember.
Okay, well, I'm gonna reset you for November 1st and the public defender's office will be out to see you shortly, okay? Thank you.
Thank you, Judge. May I be excused?
You may, thank you. I appreciate your help.
No worries.
Hold on, Mr. Luttrell. Judge, you want Mr. Gardner or do you want Gonzalez?
Gonzalez, if you have him.
Okay. Go ahead, have a seat in front of the judge. Yes. So now I see your call from Mr. Beaton or Mr. Allen.
Court will call cause number B17-670, the state of Texas versus Richard Gonzalez. For purposes of pretrial, let's say the parties.
State's ready.
Defense is ready, Your Honor. This is, I've got several motions on file. And I know that, from my previous case that had a lot of motions. I don't know if court's seen them. I don't know if I assume they're in file.
Court has not seen them, but.
I have a motion to discovery the arrest and conviction records of state's witnesses. I have a motion for notice and summary of and written summary of hearsay statements and motions that they intend to use, that the state intends to use.
Let's hang on real quick. Is the state received the motions?
Yes, they were filed prior to the original trial date before the defendant was diagnosed with COVID. Most of them are just the normal motions, but what I would suggest is if we could put it on that November, I believe it was 16th competency thing, because, or wait, no, sorry. But wait, no. November 2nd is his trial date. But again, I think it outside of the motion about whether or not his previous sexual assault conviction is admissible in the guilt innocence part of this trial. I think that the parties can come to an agreement on some of these motions, and so I think that will probably be the sole issue. So if we can, if Brett and I can have a little bit of time to go over those motions so that we can just kind of tailor them down and get it down to what I think when I looked at those motions prior to trial is I think the main thing that would be we would have to have a short hearing on is that particular motion.
Which motion is it, Ben?
It's the one about whether or not the admissibility of his previous.
Oh, is it the admissibility of his statement?
No, the admissibility of his previous sexual assault conviction in the guilt and innocence phase. It's part of the 38.
Yeah,
17, I think, is the number. But
I mean, I have it in a motion in limine about his prior convictions.
Let's do this. Let's just set all the motions for contested docket on November 19th.
Well, we've got a jury trial on November 2nd. We're a special setting.
Right. So what I was thinking is maybe on that Monday, we can have it out and give us a little bit of time to go over those motions. Again, I think that the only one that we're going to have an issue with is, or the parties won't be able to come to an agreement, is the 38-17, I believe, is the cause of it.
We can go at the end of the docket on the 1st so that we're not hindering anybody else, but I don't think that I don't think it'll take very long to do these anyway. And then I can come out and see you in the next couple of days. Well, no, you've got the old trial, don't you?
I'm going to look over them, and I'm sure we can be on the text messages. And
yeah, and that's fine. Now I'm going to be out of the country Thursday to Monday.
Okay.
But I'll probably still have my, I'll still have my phone. So
we'll get during this week, earlier this week. So
yeah, we can do that. No problem.
Okay, sounds good. Thank you, Your Honor.
Okay, good.
I think
we'll set all the contested motions for November 1st then.
Okay,
and
thank you very much.
Then my understanding is we're the number one trial for November 2nd, correct?
That's correct.
That's my understanding.
Okay, we'll see everybody back on the 1st. Thank you.
All right, Richard, I'll be out to see you, okay?
Okay.
Okay, come on, Mr.
Your Honor, that was my last guy today, and may I be excused?
You may. Thank you, Brett. We appreciate it.
Sure thing. Y'all have a good day.
See you, Brett.
Over here in court. And those aren't standard. He's wanting witness agreements. Because I can't rule on until the hearing. No, I'm just going to write to file, throw them right back in the box. But if it keeps you out of trouble, just send them. Don't worry about it. Gotcha. Cheryl, how are you?
I'm good. How are you, Judge?
Peachy. How's the big city of Fredericksburg?
It's busy every weekend.
I bet it is. It's good for the local economy, but I know it has to get a little bit old living there sometimes.
Yes, you just learn to stay away from Main Street on the weekends.
Arredondo and then Patton, and then we'll bounce back up. Try one more time. Has Arredondo been sent to the mental health program yet? Because he was found incompetent 4 months ago. Okay. Court will call cause number B20-367, 423, 424, and 425. The state of Texas versus Barry Gardner. For purposes of pretrial, let's say the parties.
State's ready.
Defense is ready.
Do we have any pretrial issues, counsel?
Not from the state.
Not from the defense today, Your Honor.
Judge, just a quick update. We're still waiting on the evaluation report on Mr. Gardner.
I have been in contact with the defense evaluator. He is just cleaning up some typographical things like a cause number. I think maybe he had Judge Patillo's name on it. So he's cleaning that up. So we should have that within the next few days. I don't know if the court wants to appoint the disinterested expert at this point.
But Judge, I know that she asked you a question, but my input would be to wait until we see what the report says.
Let's reset it for November 1st. That's only 2 weeks. And that'll give us time to get the other report, and then we can make a decision then.
Sounds like a great plan.
All right, Mr. Gardner, we'll see you back in about 2 weeks. Thank you.
All right, thank you.
Jerry, I'll come see you when I get the report.
Awesome.
If you can hear me in the jail, stop for just a moment on Arredondo.
Yes, sir.
Has he ever been shipped off to MHDD for competency restoration?
I don't believe so, Judge, and Sylvia's not here for me to ask.
Judge, they may be running together, but I have a thought that maybe we circulated an order for him to be, that was signed, at least signed by the parties and filed. But Kurt, isn't that your memory as well?
Yes, and I'm actually looking at the order that's been signed off on by all counsel and forwarded to the court, but I don't see, my office's legal assistant was looking for it, but didn't see where it had ever been entered, but I signed it, sent it back to you guys, and you guys had forwarded on to the court.
I don't have any record of the order. That's why I was asking, because we've just been sitting in limbo.
Oh.
Well, to that end, I mean, I obviously Kurt and I can make sure that if it was filed, it gets filed again, you know, so we'll do that promptly.
Okay.
I'm just going to make a note on here that we need the commitment order.
Okay, and I'll resend it because my email traffic shows that I signed it and sent it, back, but that was August 13 around that time.
All right, let's jump to Patrick Patton, please. Good Lord.
Ben, I talked to Cheryl about this one, so I'll handle it as well.
Cool.
Steve, I don't think I've done one of those in this court, so if the order needs to be revised, just let me know.
Well, I think honestly, there was a time a while back that the court sent out a form to be used on that.
Oh, okay. I didn't think I'd gotten it, but.
Okay. I'm kind of busy right now, but you may be able to call Christine and she may have one to send you.
Okay.
Okay.
Well, if you do that, it will allow me to be much more specific on when the report's due from the evaluator and so forth.
Okay.
Court will call cause number B21-237, State of Texas versus Patrick Patton. For purposes of pretrial, let's say the parties.
State's ready.
Defense is ready.
We have any pretrial issues, counsel?
Not from the state judge, but defense has communicated that they're seeking an evaluation for competency, and we're not opposed to that.
That's correct, Your Honor. I actually thought I had filed that in September, but when I was preparing for today's docket, I don't know if I didn't get it printed or I didn't get it to my secretary to notarize, but we got it filed today.
Okay. All right. When you forward the order to me, then I'll go ahead and assign Dr. Woods, and we'll see if we can get him on it as quickly as possible.
Thank you.
All right, Mr. Patton, thank you very much.
Yes, sir.
I think that's all of mine, Judge. May I be excused?
Absolutely. Thank you.
Thank you.
I would set him in like December. Well, or if you want to put something just so that he shows up. Yeah. Yeah.
Judge, are we trying Sandoval again?
We are. Third time will be the charm.
We hope.
I'll cross my fingers, Judge. I promise it's not because I'm from Eagle Pass. I promise. You know how passes are.
Well, your internet may not be any better than ours is. All right, have we gone from two ladies to one?
No, Judge, I believe they're using a phone, so it's a smaller device. So
Yeah.
Okay.
however you want to handle it, if you want to swear them one at a time, or you want them to like squeeze in a little bit.
We'll just go one at a time.
Yes, Judge.
Ma'am, can you please raise your right hand? In the matter before the court, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. Can you please give your full name to the court reporter?
Kara Cleo Westrom,
How do you spell your last name, Kara?
Westrum.
Thank you. All right, you may proceed.
Judge, does it matter to the court or make a difference that I don't see, oh, there he is. I was gonna say, I don't see Mr. Sandoval yet. Okay, may I proceed, Judge?
You may.
Thank you. Can you please state your name for the record?
Me,
Yes, ma'am.
Kara Cleo Westrum.
Ms. Westrum, and what is your relationship to Mr. Sandoval?
He's my husband.
And how long have you been married for?
10 years.
Do you share any children together?
Yes, we have one daughter.
And how old is your daughter?
7 years old.
Prior to his arrest in May of 2021, where were you all residing?
On 253 Redondo Drive.
And where is that located?
In Walburg, Texas.
Where are you currently residing?
2208 Creekside Lane with my mother-in-law, Sylvia Romero.
And where is that located?
Georgetown, Texas.
And if the court reduces Mr. Sandoval's bond to something that you can afford, where would he be residing?
There with us at Sylvia's house.
Okay. And Sylvia is Mr. Sandoval's mother, correct?
Yes.
Prior to him being in custody, was he employed?
Yes.
Where was he employed at?
At I think it's called Behringer Landscaping.
And what would he do for them?
Cut grass and landscape yards.
Approximately, I'm sorry, approximately how much was he earning?
15 an hour.
And was he full-time or part-time?
Full-time.
Now, does he have that job still, or what is the status of that employment?
Yes, they're just waiting on him just to come back to work.
In the last 5 years, has Mr. Sandoval been gainfully employed?
Yes.
Now, tell me about the relationship that Mr. Sandoval has with his daughter.
They're very close. We always go out and do family activities all the time. And he feeds her, he bathes her like your dad regularly should.
And what about his relationship with his family? Does he have close ties with his family?
Yeah, very strong. We're very all close together.
Does Mr. Sandoval travel to Mexico?
No.
Does he have a United States passport?
No.
Is he a United States citizen?
Yes.
Now, if Mr. Sandoval is bonds reduced, would you be willing to sign as a guarantor to ensure that he would show up to court?
Yes.
In the past, because it is our understanding that Mr. Sandoval has some criminal history, has he always presented himself to court?
Yes.
How has him being incarcerated these past few months impacted your family?
Well, loss of income in the family, and my daughter as well. She misses her dad every single day. And just him not being here supporting us.
Has your daughter suffered any kind of attacks or anything like that since he's been gone?
Yes.
What kind? What has she been going through?
Just sleeping and waking up scared, not knowing where her dad's at.
I have no further questions of this witness.
Mr. Harpel?
Yes, Judge, thank you. Ms. Westrum, I'm going to just kind of go in reverse order, kind of from where you just left off, and we'll work our way backwards, okay?
Okay.
Okay. And I don't mean to quibble with you, but you obviously console your daughter and you tell them where your husband is at, and you tell her the truth, right?
Well, yeah, we go visit him too, so.
Okay, all right. And then as far as you signing as a guarantor, what is your job?
I work at a manufacturing warehouse.
Okay. And my take, if you're like most of us out there in the world, it's not like you got a lot of cash sitting around the house, right? Or in a bank account.
Right.
So if the judge were to give him a bond and you were a guarantor and it was thousands or thousands of dollars, you wouldn't be able to pay the bond if he didn't show up, right?
Not by myself. I mean, we have the whole entire family helping us out.
Okay, but you said you could be a guarantor.
Yes.
Okay, I'm just making sure that I think you and I both agree that you're not in a position to show up and pay cash on a bond that was forfeited because he didn't show up.
Right.
Right? Okay. Now, you said y'all been married for 10 years, so I'm taking that you probably knew him a year or two before you got married. Is that right?
Yeah. I think
Okay, so have you known him for like, let's say 12 years?
Since I was in high school.
Okay, all right. So you're familiar with his criminal history, right?
Yes.
And that he was arrested for aggravated robbery back in 2011.
Yes.
Okay. And that he's been arrested, I mean, more than 20 times, right?
Yeah, I think so.
Yeah, and it ranges from possession of marijuana, tampering with evidence, traffic offenses, stuff like that, right?
Yes, sir.
Okay. And then he's been convicted 3 times of driving while license invalid.
Yes.
And 2 times for possession of controlled substances.
Yes, sir.
And then 2 times for possession of marijuana.
Yes.
Okay, and then at the time of this incident, and I'm not trying to go into any facts with regard to how it happened or anything like that, but he had been drinking on that occasion, correct?
On what occasion?
On the occasion that made the basis of this case we're here on.
Judge, I'm going to object as to the relevance, whether
No.
or not he was drinking, as how is that applicable to making an economical bond, or what kind of effect that's going to have over the community about him having a drink.
Well, I'm raising it from the standpoint as a condition of his bond, whether or not he's got substance abuse issues or alcohol issues.
Judge, well, then that's a more appropriate question if he has substance or drug or alcohol abuse.
Rephrase your question, please.
Okay. Does he have any substance abuse?
No.
Okay, well, we just went over how he'd been arrested for 4 times, had convictions for possession of controlled substance and possession of marijuana. Don't you think 4 convictions would make someone seem to have an issue with it?
Those were in the past. He.
Okay. All right. And what were you doing in Kerr County when this incident occurred?
My grandpa had just passed away and we were at a gathering.
Okay. And do you come to Kerr County often?
I do now to go visit him.
No, but as far, okay, and that was a poor way of asking that question. Is coming to Kerr County a normal course of your family and when he was not in jail as a part of your life to come to Kerr County?
No.
Okay. I have no further questions.
Additional questions?
Yes, Judge, if I may. Ms. Westrom, when Mr. Harper will ask you about the criminal history, let's go through it a little bit. Let's clarify. Isn't it true that the possession of a controlled substance, those were in 2017 and those were Class A misdemeanors?
Correct.
And in reference to the possession of marijuana, there's only 1 conviction in 2017 for Class B misdemeanor, correct?
Yes.
And other than that, the DWLI were Class B misdemeanors, correct?
Yes.
And one was in 2017 and one was in 2018 and one was in 2019, correct?
Yes.
And there is no conviction for the 2011 charge, correct? It's not, there was no conviction for it, correct?
Correct.
And when you said that a lot of time had passed, that was back in 2017 for any possession issues, correct?
Yes.
How much time has passed from 2017 to 2021?
A lot of time. Am I supposed to say the years or?
Okay.
4 years, sorry.
And in reference to the bond, you're going to have someone assist you, correct?
Yes.
Who's going to help you post that bond?
Sylvia Romero.
Thank you. I have no further questions.
Just a brief second, if I could, Your Honor.
You may.
Miss Westrom, I don't mean to quibble with you, but the aggravated robbery, he actually was placed on probation, correct?
I think he was.
Okay. No other questions, Judge.
Additional witnesses?
Yes, Judge, I have Ms. Romero.
Ma'am, can you please raise your right hand? In the matter before the court, you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. Can you please give your full name to the court reporter?
Sylvia Lisette Romero,
And can you spell Romero for her, please?
Romero.
Thank you. May proceed.
Thank you, Your Honor. Ms. Romero, what is your relationship to Mr. Sandoval?
He's my son.
And can you tell me a little bit about his work history, if he was employed prior to him being incarcerated in May?
Yes, he was employed with a landscaping company, and he'd been employed for like 8 years for Taco Cabana also.
Okay. And if the bond were to be reduced, would he have employment?
Yes.
Okay. What can you tell the court, what kind of relationship does your family have, the family ties with Mr. Sandoval?
Everybody's is very close to him. Everybody's helping out. Everybody's helping and asking for him. We're always spending time together.
Okay. Now, where did Mr. Sandoval used to live prior to him being incarcerated?
253 Redondo Street in Walberg, Texas.
And where will he live if the bond is reduced?
2208 Creekside Lane with me in my residence.
Okay. And in the past, has Mr. Sandoval always shown up for his court dates?
Yes, he's very good with that.
Is Mr. Sandoval a U.S. citizen?
Yes, ma'am.
To your knowledge, does he travel to Mexico?
No.
To your knowledge, does he have a United States passport?
No.
Now, the bond is currently set at, for a total for both charges, $550,000, correct?
Correct.
How much is it that you can afford to pay to post the bond?
From 10 to 12,000.
When you say 10 to 12,000, that's what you can afford to post with a bondsman, correct?
Correct.
So you're asking that the court reduce it to a total of 120,000 for both bonds, correct?
Correct, ma'am.
Did you speak to a bondsman about any payment arrangements or what you could do to afford the current bond?
Yes.
Who did you speak to?
To the Give Me a Break bond.
Okay.
Here in Georgetown.
And what was the end result of that conversation?
They were asking for too much of a down payment, but they asked us if we can reduce the bond that would work with us.
Do you currently own your home?
No.
Okay, are you renting?
Yes.
What is it that you do for a living?
I'm in manufacturing right now. I took a break from my career.
Now, if Mr. Sandoval is reduced, his bond is reduced, are you willing to be a guarantor for him to present himself in court?
Yes.
Do you have any type of retirement or savings or anything like that?
Yes.
Okay, and so if need be, if worst case scenario, they try to forfeit his bond, you'll be sacrificing some of that money to pay, correct?
Yes, ma'am. But he won't.
I have no further questions.
Sharple?
I have no questions, Judge.
Thank you. Additional witnesses?
No, Your Honor.
State?
No witnesses, Judge.
Argument?
Yes, Your Honor. Mr. Sandoval meets the factors, Your Honor, to have the bond reduced. We're asking for a total reduction to 120,000. Prior to his indictment, the total was $1 million, and Mr. Sandoval wasn't able to bond out. Now it's a total of 550,000. Mr. Sandoval is still unable to bond out. We're asking that the court reduce his bond to a total of 120,000. That way his family can post it. He does have close family ties to the community. He was gainfully employed and his employment will be back. He will have it secured. He does not travel to Mexico. He does not have a US passport. He is a United States citizen. There is no flight risk for him not to present himself to court. Although he does have some criminal history, the convictions are very minimal and mostly for misdemeanors, but there's never been an issue as to him failing to appear for court. The mother and the wife are both willing to be a guarantor to secure his presence in court. So we would ask that the bond be reduced. The bond is sufficiently high and he is unable to pay that, to post that. So we would ask that the bail be appropriate in that amount so that he can, to secure his availability for court.
Thank you. Mr. Harpole?
Yes, Your Honor. I mean, obviously, this is a very serious charge and with very serious consequences. And so those concerns that arise from any case like that, I think the court is aware of. And so with that being said, we would just defer to the court's discretion.
Court's going to deny the motions to reduce bond. We have 2801 hearings set in 2 weeks on November 1st, and we will see everybody back then.
Thank you, Judge.
And you're going to communicate with the DA about the discovery you're missing?
Yes, Your Honor, I will. And Your Honor, just for practical purposes, since I'm not familiar with this honorable court, on the 2801 hearing, is that an evidentiary hearing or is that a normal?
Look up, the best way I could tell you would be look up our local rules. It'll tell you exactly what needs to be presented at that hearing.
Yes, Your Honor, I appreciate it.
Okay, sure.
Thank you.
All right, thank you. Mr. Harpole, do we have any other cases?
No, sir, Judge. I believe that's it.
All right, I'll see you at 8 a.m. for trial.
Yes, sir. Thank you.
Thank you.
Uh-huh.